Well, joining me now is retired Judge Chris Greenland, one of our regular guests here at the Oscar Pistorius Trial Channel. Judge, great to see you.
Good afternoon.
As always, I've heard most of your discussions this morning with Devi, but I'm going to pick it up and say, take us through what Judge Masipa has to now consider as she makes her decision about this application to have Oscar Pistorius referred.
I see. Can I just go one step back first? She brought up the issue of onus. And I think it's quite important to understand that the onus here actually accrued to the court. The court has to ensure that it does not try people or convict people who are not actually responsible for their actions. So, and insofar as this has been couched, labeled an application, and Gerinel called it his application, it's not really an application by the state, by Gerinel. It's really a submission by him as an officer of that court to say, listen, it's not part of our case that Oscar was mentally incapacitated at the time he committed the offense. However, something has now arisen in Professor Foster's evidence that should, in terms of which a duty accrues to you to ensure that you don't proceed unless you first satisfy yourself that there is no mental incapacity involved here as a matter of reasonable possibility.
So you're saying that it's not necessarily up to either side to make the case for or against Oscar being referred. The court has to be sure that they are not trying somebody who could be found at any stage.
Yeah, exactly. That's very important. So even though there's been a sort of fight between Nell and Roo, the real issue here is that the judge, the court, and let's say Nell has said nothing about this at all. In terms of that decided case that Gerinel put up, where the accused, appealing against sentence, it emerged from the record, had said, I stabbed my wife, but I didn't know why I did it. The appeal court said, right there, the court should have mero moto, said, this is a warning bell, we need to investigate it. So in effect, even if Nell had said nothing about this, the court itself, Judge Masipa, would have been obliged to take the stance, and that's Nell's argument, that we need to first check this out and check it out thoroughly.
Because the test, if you like, is reasonably possibly true. It's not a case of whether he's been diagnosed or not. It's the fact that it's been brought up. We know there's an expert from the defense saying that she has a particular diagnosis. Yeah. So if at any stage it's reasonably possibly true, we need to test it.
The test is there a disorder, a psychiatric disorder, as a matter of reasonable possibility that impacted his actions at the time of the killing so as to relieve him wholly or partially of criminal responsibility. If that test is satisfied, then Roo is right.
So does it...
Sorry, Gerinel is right.
Does it boil then down to, either this entire GAD issue, this generalized anxiety disorder, is material and Oscar Pistorius should then be committed and referred, or if that is not the case, it must be ignored in its entirety?
Well, that's what must now be settled. And I anticipate that Judge Masipa will come back tomorrow and order that he be committed for examination, because in my respectful view, and it's a very respectful view, it has to be settled. Because what she can't risk is proceeding, especially to convict, with this problem unresolved. Well, if she does, she's open to being faulted on appeal or on review.
There's been a question brought up around the difference between a mental illness and a mental disorder. Barry Roo saying it would be absurd to look at this thing on the very basis of simply suggesting it in court. There has to be some kind of basis that backs that allegation or suggestion up.
Yes, whether it's a mental illness, which my colleagues have said is not properly defined. Traditionally, in terms of common law, once you have a situation whereby it can be said of an accused person that he or she didn't know what they were doing and or did not appreciate that what they were doing was wrong, you have mental disorder. Whether you call it mental illness or whether you call it mental disorder, that mitigates accountability, responsibility, so often to relieve that person of criminal responsibility. So that category of person is treated differently from a person who is convicted on the basis of being completely sane. So it is important.
How much has the evidence or the testimony of Dr. Forster then made this situation or this case somewhat complicated for the defense? Because she also conceded that on all the versions, her GAD diagnosis would still be a factor, whichever way you look at it. And it's up to the court, of course, to decide which one they're going to go with. But on all versions, she says the GAD is still an influencing factor.
Well, she has, I believe, embarrassed the defense. And she has, in fact, also embarrassed the state. Because neither side are contending for a finding that mental incapacity impacted Oscar's behavior on the night in question. So she's embarrassed all sides. And she's also presented the court with a difficulty now. The court now has to discharge an onus to ensure that mental incapacity, whether you call it mental illness or mental disorder, is played no role here.
One of the things that has been discussed around particularly the defense experts is how late it would seem some of these things have been left. Now, if one is being fair to the defense, obviously they will need to present the best case possible for their client, and they'll have to sort of make things up as they go, because of course it's an organic process. Things come out of the trial that they need to make sure they have dealt with when they bring witnesses. Does that hold? Or has part of the problem that's been created here that a lot of the information has been left late in the day?
Bongani, I'm sorry, I'm completely dissatisfied with the defense here. And if I was a presiding court, I would have by now exhibited my dissatisfaction. For instance, I probably would have done it very congenially by putting questions to Oscar at the time that he gave his evidence, because he was in difficulty. And those difficulties might have been explicable simply because he's in a confrontational situation with Gerinel. So I'd have given him the opportunity to explain what his defense was. What is not acceptable, and I think people are remarking on this, and my colleagues are adverting to it rather more diplomatically than I am, is that we are now in day 31. The trial record, I believe, is nearly 4,000 pages long, and none of us can work out what the defense actually is. I don't think that's at all acceptable. And if I was the presiding judge, I would advert to this at some stage. It's not acceptable.
Because this is something you specifically referred to when Oscar Pistorius was on the stand, that, you know, a witness finding it difficult to explain certain things doesn't necessarily mean that witness isn't credible.
Absolutely. Bongani, we have to go a step back. Take the killing itself. This is completely out of character for a person like Oscar. And he kills such a wonderful human being for apparently no reason. Right there, right at the beginning, Oscar should have been comprehensively assessed in all respects as a human being, and particularly psychologically and psychiatrically. It comes to me, I'm gobsmacked that we hear that Professor Forster, who I've said is a fantastic witness, seems to have been only commissioned a week or 2 weeks ago. I just think that is mind-boggling.
Let me go back to my first question then. Take us through the process that a judge would have to be going through this afternoon, as will Judge Masipa, in making a decision. What sort of things are going to be playing on her mind? What sort of factors will she be considering?
What she will do, she will, with the help of her assessors, first settle the facts that Professor Forster has deposed to on Oscar's condition. And then we'll take those facts and see if they satisfy or support the proposition that collectively they constitute a reasonable possibility of a mental disorder at the time that Oscar shot Riva. That's what she will do. And she will do as the judge, since she's responsible for the law, she will double check the law while her assessors squirrel away at the facts.
What are the implications if she were to come back tomorrow? Let's look at both scenarios, but if she were to, let's start with the one where she comes tomorrow and she says she's satisfied with what Dr. Forster was trying to explain to the court. She thinks this is a factor, as the defense has argued, but at no point did anyone make any assertion that it means he was directly responsible for his actions because of this diagnosis. And so if she were to say no, she's not going to have him referred, what would the implications of that be?
The test, the finding that she has to make is not that nobody made the assertion. The finding that she has to make is that the court is satisfied that there is no reasonable possibility that a psychiatric condition or a form of mental disorder played any part. She'll have to make that finding now. Not that either side are saying right or wrong.
Because it's about the court.
It's about the court. The problem is now for the court. It's the court's duty to make sure that it doesn't place itself in danger of convicting Oscar, despite the fact that his responsibility was diminished as a result of mental disorder.
And of course, if she does, have Oscar Pistorius referred, that in a sense means she's making sure she's closing any gap where that might come up later.
Yeah, I think that's her duty. That's her duty. A human right accrues to Oscar not to be convicted if he's not fully criminally responsible. So she's in effect protecting that right that he has.
As a judge, what would you have done?
I would have given my decision within 10 minutes with reasons to follow. Only, I don't fault Judge Masipa, and I said, and John Webb, to be fair, must say this. I said I wouldn't be surprised if she took until tomorrow to give a decision. The only reason I would have said, given my decision immediately with reasons to follow, is because a lot of time has already been wasted in this trial.
All right, we'll leave it there then, Judge. Thank you for your perspectives as always.
Thank you, Bongani.
After the break, we'll bring you some more of the morning session. In Pretoria, John will be talking to Barry Bateman of the EWM team.